So, what has gone on in 2023 with respect to employment law? It it has still been an interesting year, but it has not been as chaotic as 2020, 21, and 2022, mainly because we've kind of put the pandemic behind us. Um, we no longer really have COVID workplace issues. I mean, vaccine cases, although I did happen to settle one a few months back, they've essentially died out. Vaccine related human rights accommodations, COVID workplace safety. That was, I don't want to say all the rage in 2021 and 22, but for most employment counsel, that's what we spent a good chunk of our time doing. And it is nice to kind of get back to sort of the basics and dealing with issues that are not related to a once in a lifetime global pandemic. So even though 2023 has not been as chaotic, there's still been lots of interesting both decisions from courts and interesting legislative decisions from the provincial government. 2023 is, the way I like to describe it, it's kind of a continuation of the non-COVID issues we dealt with in 2020. Again, the biggest non-COVID issue in 2020 was the case of Waxdale, in which the court, after a decision from the Superior Court, an appeal to the Court of Appeal, and the Supreme Court failing to give the defendants leave to appeal to the Supreme Court, we now kind of have established law in that if a with cause termination provision violates the Employment Standards Act, even if you are terminating someone without cause and you're trying to rely on the provisions of the contract, we must read in reasonable notice. So really, before I kind of dive into this, my main statement is that things are still the same, but also very different. So let's touch on some of the big case law developments of 2023. So, as I sort of said, are we really back to normal? And the answer is, I mean, yes and no. We're back to normal in the sense that we're really not fighting over COVID related issues, but some of the cases I'm going to talk about today have a whole series of new issues that didn't really exist pre-pandemic. A lot of things with remote work, whether it's time theft or overemployment. These are some new issues that maybe existed pre-pandemic, but really came into full force now. And again, one of the cases I'm going to touch on is a really good primer of kind of what the established law around these contracts are. And again, like I said before, we have all these new considerations involving, things we had no idea about. I mean, remote work. I mean, people worked remotely pre-COVID, but I don't think I ever worked out of my office unless, I was working on a weekend. So all these kind of things are here to stay, and it's good for us to stay updated and to know what kind of changes the law has made. So the first case I want to touch on is a case coming from British Columbia, and this might be my favorite case of the year just because of some of the aspects. So Bessie and Reach CPA Inc. So this was a case at the British Columbia Civil Resolutions Tribunal, which is a tribunal that exists in BC for disputes less than $5,000. It's provided actually very fast justice as opposed to the small claims court in our province, which is incredibly backed up. But it's a tribunal that exists that you probably don't even need a lawyer to have. But this is a very interesting case because it's about time theft, which is an issue employers speak to me a lot about, in that, I have this employee and I know they're not working. What can I do about it? And I'm not saying this case stands that we have recourse for time theft at all times, but it's just something to note. So in this case, the employee Bessie was an accountant at Reach CPA from October 21 until March 2022, and her employment agreement stated that she would work remotely. The parties also signed an advance agreement stating that she would give 1/24th of the advance of her salary to the employee to purchase home office equipment and pay for the professional fees every month. Now, if her employment was terminated before the advance was forgiven, she'd be required to repay the employer should the last paycheck be sufficient. So when the employee's employment was terminated, 2903, the advance was unforgiven. So in February, the employer installed a time tracking program called TimeCamp on the employee's work laptop. And the principal of the company analyzed the TimeCamp data between February 22nd and March 25th and identified hours that the employee reported on timesheet were spent on work-related tasks. So the parties met. The principal said, "Hey, what's going on here? I need you to explain about this." And the employee said, I can't explain it. I was working. I don't know what you want from me, essentially. And as a result, the employer terminated the employee's employment. So the employee said, "Hey, you terminated me without cause, so I'm entitled to unpaid wages and pay in lieu of notice." Now, the employer said, "I terminated you for cause because you engaged in time theft. Therefore, you're not entitled to the termination pay or pay in lieu of notice." And the employer also counterclaimed for the paid wages. It claimed if counterclaimed for the paid wages as it claimed it was time theft. So in front of the tribunal, the employer submitted videos showing how TimeCamp tracked the time and activity, and they claim they proved that the employee engaged in time theft. So the employee did not dispute the video evidence, but she claimed that TimeCamp was difficult to use and she couldn't get it to differentiate between time spent working and time spent on the laptop for personal use. The employee also said, "I do a lot of work with paper documents, with paper copies of client docs, which TimeCamp wouldn't capture." So the tribunal found that TimeCamp likely accurately recorded the work activity, and there were about 51 unaccounted hours recorded on her timesheets. So based on a contextual analysis of the facts, the employer had just cause for terminating the employee's employment for engaging in time theft. So because they had just cause, she was not entitled to notice of her dismissal or termination pay in lieu of notice. So did the employee owe the employer paid wages for time theft? And the tribunal concluded that the employee owed the employer time theft or compensation for the 50.67 unaccounted hours. Now, the tribunal also found that the employer was entitled to withhold the entire amount of the final paycheck to cover part of the unforgiven 2903. Now, what is kind of the bottom line for employers here? The reason why I like this case so much is I have clients calling me all the time saying, "How can I deal with someone for time theft?" And my thinking is that if you have accurate data that demonstrates time theft like this, sure, okay, we can try and terminate for cause. But for the most part, think most I think most time theft claims are a little bit difficult to prove. So what do you do if you're an employer and you have all these employees working remotely? And that should we all install time tracking software? How do we deal with this? And again, I'm not a privacy lawyer. I don't necessarily deal with these time tracking softwares, but I think something that needs to be considered is that really you need to hire people who you believe are going to do the work if they're working remotely. And it's easier said than done from my end, just because I'm not the one doing the hiring. It's hard to reconcile immediately if someone is going to be a good employee. But it's something just to note. But again, if we do have legitimate belief that there is time theft, we can try and terminate for cause. So the next case I want to touch on deals with a different type of time theft, overemployment. I don't know how many of you are familiar with the concept of overemployment. I don't know if anyone ever spends time on Reddit, but there's a very interesting subreddit called overemployment in which people juggle multiple remote jobs. And you see people try and say, "How do I get around this in-person meeting?" or "How do I do this and that?" It's a good laugh at the end of the day. But is someone allowed to is someone allowed to be overemployed or have a quote unquote side hustle? I mean, side hustling is not really a new phenomenon. I mean, costs of living have gone up, inflation has increased. There's some survey data from Angus Reid in that 25% of small businesses in Canada were started during the pandemic, with 51% of those entrepreneurs likely to have multi hustles rather than one business. And there's some data from Accenture that shows that 41% of Canadians plan to take on a side hustle in order to supplement their income. So, can the employee have multiple jobs? I mean, what we're going to go through in this case is having a second job without the employer's express permission can come with its own costs. So, Destiny Media Technologies, I'm just going to refer to them as Destiny, hired employee Miss Dove in 2009. And she was responsible for managing the company's list management service, which was a software based platform for marketing music within the music industry. Before she was hired on a full time basis, Miss Dove was allowed to use company premises to work on a small business that she operated. And in return, she did some admin work for the company. But in 2009, once she became a full time employee, the company made it known to her that she was no longer allowed to work on this business in the company's office. So, when in the court decision, which I'm going to touch on, the court found that this employee should have understood this to be an indication that all outside work was prohibited during working hours. So, over a 6 month period between January and June 2017, Ms. Dove worked at a cafe during work hours, and she did not have prior approval from company management. She devoted at least 3 to 4 hours per week due to the cafe. So, this side hustle directly and detrimentally impacted her work for the company and her ability to execute responsibilities in a timely and productive manner. For example, she failed to respond to a lot of emails to her internal email address. She struggled to meet deadlines and was regularly absent from work without prior approval. Additionally, on at least one occasion, she stored goods intended for the cafe at the company's premises and directed another employee to help her produce signage for the cafe during their working hours, which that statement right there just had me chuckle a little bit because it's so patently ridiculous. So the company kind of got sick and tired of this, and in June 2017, they terminated her for cause, which, as a note, goes to show you how slow the civil courts are in that she was terminated in 2017, and we only had a hearing for this matter in 2023. So the court found that the company had just cause for Ms. Dove's dismissal in the circumstances. The court upheld the dismissal despite any absence of any formal warning to Ms. Dove. The court ruled that despite any formal warning, it should have been obvious to Ms. Dove that her employment was at risk of termination. Additionally, Ms. Dove refused to cooperate in an investigation, which eliminated the company's ability to use the investigation into her side hustle as a means of alerting her to the precise nature of its concerns. The court dismissed her argument that she was fitting her cafe work in and around a full work commitment to the company, stating that this suggestion was undermined by her inability to actually do her job. In any event, the court indicated that employees are not free to simply allocate their work time to other commitments without the consent of their employer, regardless of whether or not they're busy. So, what does this decision tell us? That dismissal for cause may be an appropriate response where the employee is engaged in a side hustle during business hours without the permission of their employer. Employers should undertake a thorough investigation of any concerns regarding potential side hustling in order to ensure that their eventual response is proportionate and defensible in the event of a challenge. And this case also tells us it's all about the contract. Your employment contract should implement clear written restrictions regarding use of company time for personal business. Now, again, what does this case tell us? Is it wrong for an employee to kind of have a second job or a side hustle? I mean, if they're doing the job during working hours, that's not good, and you should definitely document this and institute some form of performance management. If they're doing the job outside of the regular hours and it has no impact on their job, as long as they're not directly competing with your business, and there's a non-solicitation clause in that employment agreement, then we're probably fine. So the next case I want to touch on deals with one of my favorite topics in employment law, bad faith damages. So a lot of times I will get a letter I will have one of my clients forward a letter to me from, from an employee that has been dismissed. And the employee is claiming bad faith damages for the manner of their termination. And there's no real definition as to what bad faith damages are, but it's one of those things when the court sees it, they know exactly what it is. So this case is a great summary to go through what bad faith damages and the relation of termination may be, and some strategies employers can use to ensure that a court will not award bad faith damages. So in in this case, in Telger versus Aurora, Telger and Aurora Group, you know, it appeared to be a standard wrongful dismissal. But at trial, the employer awarded 7 months of reasonable notice and $15,000 in bad faith damages for the employer's breach of its obligations of the duty of good faith. So the employer, Aurora, dismissed the plaintiff, who was a 56-year-old employee without cause, and they had over 3 years in a senior management role. Now, the employee secretly recorded the termination meeting, which is allowed on the employee end. Employers, don't record your termination meetings. Ensure that there is someone there taking notes. Do not do that if I can provide you with any advice. So in this recording was used as evidence by the motion judge by awarding moral damages. So what did this employer fail to do? They failed to give the employee written notice of termination after the employee asked for at least 3 times for something in writing. Now, this is a direct contravention of Section 54 of the Employment Standards Act, which, if you've been at a company for more than 3 months, you need written notice of termination. So again, your first step, provide a written termination letter. The employer failed to provide the employee with their minimum statutory entitlements within 7 days after the termination or on the employee's next regular payday. Again, direct contravention of Section 11.5 of the Employment Standards Act. So this delay in providing these funds meant the employee had to go through the holiday season without any financial support from his former employer. The company also failed to reimburse the employee almost $17,000 for incurred business expenses, which was about 23% of his annual income. And again, this was a pretty big financial burden for the employee to carry. In the termination, employer indicated that this employee would be paid out before the next week or so, but failed to do so even to the date of the summary judgment motion almost a year later. In the termination meeting, the employer assured the employee that they would receive additional funds, but instead limited the amount paid to the Employment Standards Act entitlement of 3 weeks. In the termination meeting, the employer also encouraged the employee to resign from its employment, saying, it's better off for you if you just resign. And, in totality, these are all what we would describe as bad faith actions. Maybe one of these alone wouldn't constitute bad faith, but the entirety of this, we are looking at some serious damages. So how do we avoid moral damages for bad faith conduct? It's relatively simple. Employers have to fulfill their statutory and additional contractual obligations and ensure that they are honest to employees and follow through on their promises. Even what may seem like individual insignificant missteps will be scrutinized and assessed collectively, with particular regard for an employee's vulnerability and unnecessary mental distress at termination. So again, what do employers do? Employers need to ensure that managers, human resources, payroll staff are well trained on the process of dismissing employees and the best practices in cases where misconduct is not alleged. This should involve a review of company policies on how to handle these terminations to ensure that the company is not unknowingly engaged in practices that would draw the ire of a court or tribunal. Now, again, with the recordings of the conversations, employees can record the conversation. So ensure that your managers and human resources professionals are aware of this possibility and conduct themselves accordingly. I tend, when I advise employers on termination meetings, I just say, if you're alleging no cause, provide them with the letter and just say, you know what, this isn't working out. We wish you all the best in your next opportunity. We're going to provide you with your statutory entitlements. Common law entitlements, different story. That all depends on the contract. But really, keep a script. That is the best advice I can give. So, the final case I kind of want to touch on today is, again, it is a case in which we are just reestablishing the principles of Waxted from 2020. It's really all about the contract. Now, the court, the pendulum that we're currently at is a very employee friendly side. 10, 15 years ago, Ontario was much more employer friendly. Now, will there be a return to employer friendly policies and law and case law? For now, I say no. So we really need to ensure that our contracts are ironclad. So I'm going to run through this final case and provide some potential recommendations. So Tan and Stosic Inc. So Ontario courts are continuing to scrutinize this termination clause. And again, this is going to continue. So despite a saving provision that purported to incorporate the ESA standards into the agreement, the Superior Court of Justice found that this termination clause was unenforceable for the principles articulated in Waxdale. So the situation is very similar. Employee is terminated without cause. Court finds they're entitled to common law reasonable notice because the contractual termination provision with cause termination violated the ESA, therefore rendering the entire termination provision void and unenforceable. So the contractual termination provision provided the employer could terminate the employee without notice or pay for any just cause. So the court concluded that the termination provision gave the employer the right to terminate the employment without notice or pay of notice for just cause in a manner that might fall short of non-trivial willful misconduct. So in the Employment Standards Act, the only way you can terminate an employee without any statutory minimums. Now, again, if you are alleging just cause as stated by the common law, you still have to pay them their statutory minimums. But the only way you can get around this is there is in one of the ESA regulations, OREG 28801, employees, you can only not provide termination pay to an employee who is guilty of willful misconduct, disobedience, or willful neglect that is not trivial or has not been condoned by the employer. Now, again, I could probably do a whole presentation on what this willful misconduct standard is. And there was a great case last year, involved from early last year, dealing with the willful misconduct standard. But essentially, willful misconduct needs to be it needs to be pre-planned, essentially being bad on purpose and know you're being bad. But let's kind of move back to this. So the court found that that despite it contained a saving provision stating that if this contract violates any provisions of the ESA, it'll be deemed to essentially be, we will read in the minimum standards. Now, the judge found that the employer could terminate that this could end up in a situation where the employee could be terminated for just cause and not for just cause, not the willful misconduct standard, and not receive their statutory entitlements. So following kind of Waxdale, courts are really hammering down these employment agreements. And again, if you are using pre-2020 employment agreements, I strongly recommend you have a lawyer look at them, check them out, because there's a good chance that it probably violates the Employment Standards Act, and you could be responsible for common law reasonable notice, even if your agreement limits them to the statutory minimums as described by the Act. So then, what is going to happen in 2024 in terms of case law? And the answer is, I don't really know. The big trends of the last few years have kind of been put to bed in that we don't really care about vaccine cases anymore. We don't really care about infectious disease emergency leave cases anymore. What is going to be the new trend? And I think there are going to be cases involving the just cause standard and maybe some potential time theft cases. But 2024 is a new year. It has not started yet, but I'm looking forward to see what's going on. So, moving on to the legislative updates, the provincial government has been very, very busy. They have passed the third version of the Working for Workers Act 2023, and the fourth version of this act, Working for Workers 4 Act, which strange title, but I'll let the government have it. That has not been passed yet, but I presume it will be passed in early 2024. So these are two pretty big bills that they have passed, kind of really adding in, it's really modernizing the employment law regime. So the first thing I want to touch on is something that was passed in 2022 but came into fruition in 2023, and those are naloxone kits. So if you are a workplace in which there is a risk of worker opioid overdose, there's a risk that the worker overdoses while in a workplace where they perform work for the employer, and the risk is posed by a worker who performs work for the employer. I'm going to break all those three down in a minute. You needed to have a naloxone kit by June 1st. So what does that mean? What do all these things mean? Risk of worker opioid overdose. So essentially, the employer can become aware that there may be a risk that the worker could have an opioid overdose. And what are some ways? I mean, a worker overdose could have already happened. A worker who uses opioids may voluntarily disclose this risk to the employer. An employer may observe opioid use, or an employer could find, discarded paraphernalia such as needles in the workplace. Now, this OHSA requirement does not apply to workplaces where the risk of the overdose is created by a non-worker, such as a customer, a client, or a patient. So what does the second requirement mean? There is a risk of worker opioid overdose happening in the workplace where the worker performs work for the employer. So for this requirement to apply, there needs to be a risk of the worker having the overdose in the workplace where the worker performs work for the employer. And the requirements don't apply if there's a risk of it happening outside the workplace. So an example of this would be, an employer could be aware that a worker on leave from the workplace is at risk of having the overdose. But because the worker is not presently working, there's no risk of the worker overdosing at work. So in this scenario, employer would not be required to have a naloxone kit in the workplace under the OHSA. So the third and final trigger. The risk is posed by a worker who performs work for the employer. So for this requirement to apply, the risk of having a overdose at the workplace must be from the worker that performs work for the employer. So for example, if the risk of the overdose is presented by a worker of one employer while on a work site shared by multiple employers, only the employer of the worker who is at risk would be required to provide the kit in the workplace. So an employer would not need to comply with this requirement if there's no risk that a worker would have an opioid overdose at the workplace, and the worker is at risk of having an opioid overdose in the workplace, but that worker does not perform work for the employer. So that is something that came into force. Again, if you're a workplace that I see someone put a question in. Again, you know what? I'm going to handle all questions kind of at the end. We'll do kind of the question and answer. So, Working for Workers Act 2023. So again, like I said, the government has been pretty busy about all of this. Third iteration came into effect on October 26th. So what did the government put into place? The first thing is mass terminations. So now remote workers are expressly included in the Employment Standards Act's mass termination rules. The mass termination rules provide for enhanced notice period where 50 or more employees are terminated at an establishment in a 4-week period. So this bill amended the definition of establishment to include an employee's private residence if the employee works from that residence and does not perform work at any other location where the employer carries on business. So as a result, mass termination scenarios for remote workers may count towards the 50 termination threshold and may have enhanced termination entitlements. The next thing is reservist leave. This isn't something super common, but the ESA covers everything. So eligibility for reservist leave is expanded to include circumstances where an employee is in treatment, recovery, or rehabilitation for an illness or injury resulting from participation in the reservist activities. The service requirement for reservist leave eligibility is reduced from 3 months to 2 months. We also have some revisions to temporary help agencies. So, there's a new licensing criteria for THAs and recruiters to enhance protections for foreign nationals. So now licensing recruiters, there are more stringent requirements for recruiters to prevent practices such as charging fees to foreign nationals. So it amends the Employment Protection for Foreign Nationals Act to provide that the Ontario Labor Relations Board would be required to reduce penalties associated with notice of contraventions related to a person taking possession or retaining a foreign national's passport in situations where the board determines the penalty is excessive in the circumstances. Now, what else is there under this act? So the maximum fine for Occupational Health and Safety Acts for safety offenses has been increased from 1.5 million to 2 million. Now, generally, for a first-time offense under the act, you're not going to see a fine that high, even if it unfortunately involves the death of a worker. Those $1 million, $2 million fines exist when companies have been in constant contravention of the act, and it is kind of the last straw. So the final kind of big change to under the Working for Workers Act 3 is some changes to the Fair Access to Regulated Professional and Compulsory Trades Act. So regulated professions such as nursing, teachers, anyone who is subject to regulations pursuant to a professional college, they now have a duty to work in consultation with the government to ensure that a matter of public interest, there's an adequate number of qualified, skilled, and competent regulated professionals in Ontario. And another thing that they want to do is alternatives to Canadian experience. So if a regulated profession accepts Canadian experience as one way of qualifying for registration, they must now also provide alternatives for Canadian experience. So the last thing I want to touch on is the final aspect of the Working for Workers Act, Working for Workers Act 4. Again, I think this is a pretty interesting bill. Although if Doug Ford had asked me, I would have changed the name. It's something with a little more jazz and something that flowed better. But let's kind of go through some of the big things. So, bill, this bill, also known as Bill 148, it has not passed yet. I presume it will pass early next year when it's read by the government and MPPs can vote on it. But what are some changes that it's proposing? So the first thing are some requirements for job postings. So it's going to require employers to disclose expected salary ranges for the position, similar to requirements recently implemented in BC. Now, will this be all jobs with salary requirements? I am not 100% sure at this point. I think the government is kind of looking for like a magic number, at least for salaried employees. I mean, they're still accepting consultation. I have heard rumblings that you will only need to disclose it if it is over $100,000 a year or more. But again, that is just rumbling. So once something actually comes into fruition, we'll know. Now, it also is going to prohibit requirements related to Canadian work experience in both job postings and application forms. And I do see this, I do see this a lot. And even now, I tell employers not to do so because you're running the risk of a human rights complaint in that you are discriminating in hiring based on creed, nationality, and other protected grounds under the Human Rights Code. Now, another thing it's going to change is it's going to require employers to disclose the use of artificial intelligence in their hiring process. And again, I don't know how many employers in Ontario are using AI for selection now, but we're still kind of in the infancy stages of artificial intelligence, in which I'm sure a lot of people here have used ChatGPT. I tried to use it relatively recently to give me the best fantasy football lineup possible, but unfortunately, ChatGPT says they are not a predictive model. But are employers using AI related software for hiring? And I haven't really spoken to any of my clients who are doing so. But again, it's one thing to note that if you are using, again, AI can be useful. It can take a lot of the biases we have out of decision making. But at the same time, we don't know the inputs or the inputs and the outputs that AI is looking at. So again, it may overemphasize certain factors or underemphasize certain factors. So really, we should be a little careful using AI in the process. But we also you're going to have to inform potential employees that you are using it. Now, another thing that Bill 149 is going to do is it's going to implement tip and wage protection for workers in the service industry, including if you're running a restaurant, you're going to have to require employers to pay workers for trial shifts. None of these kind of working interviews where the person doesn't get paid. And it's going to prohibit employers from deducting any amount from an employee's wages where the customer at a restaurant, a gas station, or any sort of other establishment leaves without payment. And it's going to require any employer who has a tip sharing or a tip pooling policy to post a copy of that policy in a location that's visible to all employees. And I think this is actually pretty good in the sense that transparency in the workplace is pretty good, because a lot of times employees get frustrated because they feel as if management is leaving them out to dry. I've heard all the same kind of issues, but transparency is always good so that, if an employee ever has a complaint, you can just point to the policy. Now, another thing that this is going to deal with is, it's employers will be restricted in the method of paying tips, which are either going to have to be paid in cash, a check payable to the employee, or direct deposit. Now, again, this proposed change it's in response to the rise of digital payment platforms in the service industry, which may pose a security risk or require workers to incur fees to access their funds. I mean, again, some people's bank accounts, they get charged when it comes to intra-ID transfers, or it can sometimes be inaccessible to access the funds. So providing it by cash, check, or direct deposit is a great way. Another thing to take into consideration are vacation pay requirements. Now, sometimes, it used to be you would pay the employee for their vacation pay when they took the vacation. But now you will be allowed to agree with the employee. You can agree in writing that they'll either receive the vacation pay when they take vacation, or at any point or on their regular paychecks. So really, it's just about hammering out ambiguities. And two final changes I want to touch on are this new bill is going to potentially assist injured workers by enabling super indexing increases to the WSIB above the annual rate of inflation. So, for example, an injured worker who earns $70,000 a year, 2% increase could mean an additional $900 annually on top of cost of living adjustments, which was 6.5% in 2023. And one final thing that the government wants to touch on is they are going to launch consultations regarding restrictions for the use of non-disclosure agreements in the settlement cases of workplace sexual harassment, misconduct, or violence. And they also want to create a new job protected leave for critical illness for something like cancer to match the length of the 26-week federal employment insurance sickness benefits. So, like I said, Bill 79 has already been passed. So, you should be adhering to it. Bill 149 has not been passed yet. Now, in terms of kind of looking ahead to 2024, what is going to be a big change? And I think one thing that we're going to be looking at is temporary help agencies. So this year, the government announced that temporary help agencies would have to have a license. And, I had issues from a lot of clients because one of the things the government wanted was a letter of credit in which they had to put up something. I think the number was $25,000, and it seems as if the government didn't do enough consultation with smaller temporary help agencies. So really, the licensing provisions were supposed to come into full force in the end of this year, but they've pushed those back to July 2021, July 1, 2024. And who knows, they may push them even again. So, like bring this all full circle. 2023 has been an interesting year. It has not been as chaotic as 20, 21, and 22, but I think a lot of interesting things have happened this year. So I think now we're going to kind of move on to the question and answer session that's going to be facilitated. And, I hope you were all able to learn something from today. And again, if you have any questions, concerns, or comments, feel free to contact me, and I'd be happy to have a chat with you about whatever workplace issues your business or company is facing. So let's lean into the question and answer.